Transform. This is 702 for the curious.
14 minutes to go before we get to 9 o'clock. Now, as I said, we're going to have a conversation that is quite interesting, and maybe because of a legal perspective, the legal issues surrounding it. But at the very same time, I'm not too familiar with this. I wasn't even aware that this was a thing, the Copyright Amendment Bill. Now, I'll be speaking to two people now. First and foremost, I'll be speaking to Herman Blignaut, who is a partner at Spoor and Fisher. And then after that, Mpuka Radinki, who's the Executive Director of the Publishers Association of South Africa. Now, I think the most important and obvious question to ask, Herman, good evening to you, is what is the Copyright Amendment Bill and why is it being introduced?
Well, good evening. The Copyright Amendment Bill is a work that has a long and checkered history. I believe that way back in 2015, the first draft of the bill was published for public participation, and ever since then it has drawn tremendous criticism from stakeholders, from people involved in a specific field of law. Some of the provisions more controversial than others. The copyright bill is really a necessity at this point. It seeks to update the Copyright Act, which was promulgated way back in 1978. And there are many amendments that seek to update the copyright law in South Africa. But if I can just jump in and start with probably the most controversial issues, which is really, some terms that enable universities and academic institutions to sort of almost have a free-for-all, ability to copy or reproduce copyright-protected works.
Okay.
And then, sort of ancillary to that, there are provisions relating to fair use, which seek to replace or substitute existing provisions on fair dealing. And probably the biggest concern with these, and I believe that it will be supported by my colleagues, who will speak on behalf of PASA, is that when you enable people to simply reproduce protected works, you really take away the incentive of authors to create or update existing or new works, which means that if you are not compensated for work that you've created, what you will in effect be doing is to take away existing jobs or demoralize and demotivate authors from creating new works. And this is probably what will be achieved, what the biggest concerns are by the Copyright Amendment Bill. There are many other provisions that really, are necessary, as I said. So it's a work in progress and a little bit overdue. But the big concerns is that there are numerous stakeholders that have commented, that have made written submissions, oral submissions, that there are great risk posed by the Copyright Amendment Bill, and these seem to have been ignored for one reason or another. One does not seek to change something just for the sake of changing it. There is either a process that you need to improve or streamline, a necessary change to find a solution for something, and these changes which are being proposed, are quite suspect in that there's probably a sort of a political agenda that it seeks to serve. If I may just mention, this has not been published by any of the draft persons or people involved from DTI or the Parliamentary Portfolio Committee, but we know all about fees must fall and the pressure on government to enable students to study for free, specifically higher learning, higher education.
Sure.
And, there's, as a result of that, been tremendous pressure on, for example, universities to be cost-conscious, to cut costs where they can in order to subsidize, what student fees would otherwise have done. And my suspicion is that this is but one of the measures that governments seek to alleviate this burden of costs on students and universities, because up to now, students and universities have been paying for works that are being reproduced. But if the Copyright Amendment Bill goes through, you are looking at a tremendous sum of revenue that they might be able to save, and that might otherwise go to subsidizing free education.
So, look, what I'm just looking at is, I mean, I want to just take us one step back, and you were talking about obviously universities and free, not free, but fair use principles in that particular instance. And generally speaking, universities they're not Napster. They're not going to download songs or books and, copy them and just distribute them for free. But I'm sure that there is some fair usage principle that comes into play. As I said, I'm not familiar with the legislation myself, but I mean, in terms of me as a private individual, being Gershwell Brooks, how does that copyright impact me? So in other words, how does it prevent me from going through the legal and correct channels to ensure that the music I'm listening to, the books I'm reading, the movies I'm watching, and whatever other artistic material I'm accessing, that the person who actually created it and is due those royalties actually receives those royalties? Because surely, that's usually where the biggest pitfall comes into it. Is it not so?
Yes, indeed. I intimated earlier to existing provisions on fair dealing that exists already in South African copyright law. And what these provisions enable people to do is, any person can, for their own private and personal use or private study purposes, for example, copy, reproduce, or deal with a protected work in such a way as the Copyright Act generally or otherwise prohibits. So those provisions are already in place. Which means that if I were to take a textbook, for example, or a song, reproduce it, listen to it for my own personal and private use, that would fall within the ambit of fair dealing, which the Copyright Act excuses as a form of copyright infringement. But what the Copyright Amendment Bill seems to do is go far beyond. If I could also just add, up until now in South African jurisprudence, there's never been the need for South African courts to interpret or rule on an issue pertaining to fair dealing, which suggests one thing, is that it has not been a problem up to date. Now, it brings me back to my comment where I said earlier that you don't just change something for the sake of changing it. What is the agenda? What is the objective that you seek to achieve by changing the law in this respect? And, numerous sort of commentators have suggested that it has to do with the likes of Google and the YouTubes of the world, the big internet companies that want to be protected. If you take an existing book and you digitize it and you put it on your platform, is that not a type of copyright infringement if you don't have authority to do so? Yes, it is. But what fair use, which is the new type of conduct that the Copyright Amendment Bill seeks to introduce, it leaves a much more open-ended defense to copyright infringement, which probably, goes way beyond. It really defeats the purpose for which copyright law was intended.
So if I can just quickly jump in there because of time constraints, and what I'll do then is I'll speak to Mpuka Radinki after the 9 o'clock Eyewitness News. What I just want to understand from your side then is in terms of this legislation. So I hear what you're saying, that a lot of these issues that have come up, that are being supposedly addressed by this new legislation, are things that we haven't even seen in our courts. But we are living in a modern age where a lot of stuff is internet based, and you know this very well. An author's book gets released today, and then tomorrow someone will WhatsApp me the PDF version of that book and a high quality PDF on top of it, and that particular author then loses out on the royalties I would have paid him indirectly through purchasing the book. So what I'd just like to understand though is this then a burden or a blessing when it comes to this legislation, and why? Just very short, in short.
I think it's a burden. I think that you are probably killing the industry if you take away the ability of someone to make a livelihood of creating works that are protected by copyright. And when we talk about copyright, it's not just books. It's not just music. It has to do with the likes of, the well-publicized Game of Thrones. It seems to be a hot topic, now that the last season has started, where the concern is that the moment it gets aired, by the next morning it's available on, pirated sites. And this is one of the reasons that producers have created sort of a multiplicity of possible different endings to Game of Thrones that no one can predict how it will end. But I mean, you really look at a very broad category of works that are protected by copyright. And if you go overboard by allowing the public at large to, just render...
Herman, can I ask you, I'm sorry, because of time, let me ask you to wrap up that thought after the 9 o'clock Eyewitness News, okay? That was Herman Blignaut.
702. 702. For the Curious. On 92.7 and 106 FM.
Welcome back. It is 5 minutes past 9 o'clock. So this conversation we just carried over quickly to this hour, and we're discussing this new piece of legislation that has come out, of course, and the president about to sign it. But of course, there's opposition to it, a copyright amendment bill, and that's what we're having a conversation about. And Herman Blignaut was just outlining some of the defects or deficits with this particular bill, and how it can impact on creative works. Now, Herman, it's great to have you back. You were just busy wrapping up and explaining to us why this piece of legislation is actually problematic.
Yes, one tends to focus on the negative, but I should have also said from the outset that it is a comprehensive piece of legislation that seeks to address various different issues. But what we are focusing on is, where the potential problems lie, and where there could be constitutional challenges, if the president were to adopt the act or sign it off. Now, to focus on, the creative industry, specifically authors that write textbooks, that write academic works and the like, these are normally quite specialized fields where it's not just any Tom, Dick, and Harry that can decide to write a book on a specific academic issue. And if these authors were to be decentralized from creating new works, it just spells disaster for the industry,
so
and
just as a
longer term impact on students and the consumers generally.
So, just as you're explaining that, the one thing that stands out for me immediately, and I'm thinking about my varsity days where I think in first year I was able to, not even able to then, but I went out and I bought textbooks, and they were very, very expensive. They were prohibitively expensive, but obviously in subsequent years after that, quite frankly, I spent a lot of time in the library. That was the alternative. You take the textbook, and you can only use it for the day. You take the textbook, and in the library, you sit down, you take your notes, and then you have to hand it right back. And that makes, obviously, that's how a lot of us sort of bypass that. So I would say that a very small proportion of the students actually bought it. So does this still impact on those authors, because they're professors and specialists in that particular field, not just any Tom, Dick, or Harry is going to write about the law of delict as an example. Someone that is a specialist in that space is going to write it, but it's not going to be a bestseller by any stretch of the imagination.
Yeah, so that's not the kind of work you're talking about here, that the latest bestseller, Tom Clancy or Dan Brown or whoever. It's not that academic field where universities and academic institutions are now allowed to do sort of wholesale copying. And if we take ourselves back to varsity days, you may have bought the prescribed textbook, but that's not where it ended. As a law student, I had to refer to many different law reports. That was part of our course material. Whether it was law reports published by Tutor or Butterworth, you had reference to academic articles, all of which did not necessarily form part of your single prescribed textbooks. Now, what universities also do, and whether that's in hard copy or digital form, is they create course packs or study guides, or call it whatever you like, but it's a compilation of works that have been extracted from different sources and compiled for the students' convenience to be able to have, used as a single reference guide. Now, what about that? Certainly, that can't, just be reproduced to the detriment of the authors whose articles have been copied, or extracts of articles copied, or the publishers who put all these law reports together and the like. As I said earlier, up until now, universities and students are paying for all of this. What the new copyright and what the Copyright Amendment Bill probably in effect will do or cause is that all of these works would now become available for wholesale copying without the royalties that are due going to the various different authors. And that is a problem. It's a problem for copyright, it's a problem for authors, it's a problem for the academic field. Again, if there is no incentivization, it will cause just, a lack of works in the longer term in that specific field.
This is a final question before I let you go. It's a question actually from a listener saying that thank you for discussing the copyright bill. I'm about to self-publish a book on wildlife. I have my ISBN number. Should I trademark the name? I want to do a trading as not open a company. Unfortunately, just moved there. So I certainly cannot register a company. I'm concerned someone bigger and better copies my name and concept. According to my lawyer friend, I don't have to trademark the name of the book. I'm very concerned about the copyright. My book has a very catchy name for a fabulous concept. Still secret, my lawyer friend is not a publishing lawyer, which I think is a fair question because I think a lot of people are interested in self-publishing. They're working on stuff. I know I myself find myself in a similar situation, and you don't necessarily go to a copyright lawyer because guess what? A lot of the time, Herman, with all due respect, you guys pay, you charge quite a pretty penny.
If I can jump into the question straight away, this is an interesting question because it raises more than one issue, more than one type of intellectual property rights. And whilst we've discussed copyright, and copyright would generally protect the contents of the book that this person is publishing, the name is protectable entirely separately as a trademark. And trademarks can be registered. He says he's not inclined to do so. That's entirely his prerogative. Nothing forces or obliges the person to protect the trademark. But if it's a catchy name and it's worth protecting, it's worth registering. So on the one hand, you will have the title that no one else can use as a mark for themselves or anything confusingly similar. So that's trademark protection on the one side. On the other side, copyright protection subsists automatically in the literary work once it's been written, and that is if on condition that the work is original and it's in material form. It's not just a thought or an idea that the person is playing with, but there's already black ink on white paper, or it's saved on the computer's hard drive. So it must be original in the sense that it's not being copied from any other work, but that it was created through the author's own effort and skill and in material form. And then you've got copyright vesting in the contents of the book and the title being protectable as a trademark separately.
100%. Thank you for that, Herman. I will be seeing you for my free consultation. All the best to you.
You are more than welcome. I look forward to it.
That was Herman Blignaut, partner at Spoor and Fisher. Now, to continue the conversation, we have Mpuka Radinki, Executive Director of the Publishers Association of South Africa, on the line, speaking on behalf of the Coalition for Effective Copyright. Mpuka, Herman gave us sort of the legal bits and pieces, the bolts and the nuts there. Yourselves, as speaking on behalf of people that are obviously in the publishing space or want to publish things, what's your take on all of this?
Yeah, I'd like to echo a lot of what Herman stated, which is that the Copyright Amendment Bill expressly put as one of its objectives the improvement of the lives of the creators to ensure that they enhance their earning capacity of from their creative works. That was one of the key objectives included in the Memorandum of Objects. However, we think that some of the benefits that have been put in the copyright bill, such as ensuring that creators, authors, and the like get royalties, are really undermined by constraints placed on them, especially by allowing free uses of their works, and the failure of the copyright bill to support enforcement to ensure that copyright is protected.
For sure. I see that there's a couple of concerns that you have, and I'm very interested by the fact that you're raising the issue of that it's a contravention of Section 25, of course, which is the section of the Constitution that's actually at this very moment under a serious scrutiny, and this is obviously around property and the arbitrary, not necessarily, or preventing the arbitrary deprivation of property. And you are stating this as part of your concern, that this is actually an infringement on your rights.
Yes. If you go back to what Herman was saying, Section 12 especially has got very, very wide exceptions that are very, very broad to a point where, say, authors, for instance, will not be able to benefit from their works. In other words, those wide exceptions will ensure that people can use those works without seeking permission and without remunerating the copyright holders. And it does that through the general and specific exceptions, as well as the introduction of a hybrid model that is grounded on fair use, to use the parliamentary language. Those two, remember that exceptions are cases where you do not have to remunerate, rather to seek permission or to compensate copyright holders. Therefore, if those exceptions are so wide, as you see them in Section 12, actually from the whole of Section 12, A to D, if they are that wide, then we can guarantee you that what has actually happened is that the ability of the creators to earn from their works has been removed. And therefore, that becomes indirectly deprivation of the ability to earn from your property. And that is why we talk about that the fact that the bill is inconsistent with the Constitution. For the using the introduction of a U.S. style fair use, we do not necessarily have problems with fair use per se.
Okay.
But the type of fair use that has been introduced in South Africa does not come with statutory damages that counterbalances the excesses of fair use, which means it's really, as Herman said, it's a free-for-all. All you need to do is to bring up fair use as a defense to copyright infringement, then voila, you can use anyone's creative works. So the wide exceptions and the transplanted U.S. style fair use that has not been brought without the statutory damages will make sure that creators in practically all creative sectors find themselves in a non-viable business environment, and therefore their property being deprived somehow.
So I just wanted to know, I mean, it's a beautiful articulation of, the constitutional dilemma that you're faced with. But obviously now the next question, the final question that I have for you is, what's the next step? Because either you're going to hamstring this situation or this issue by going to the president or finding an emissary and telling the president that, listen, please hold on, don't sign this thing. This is why it's so problematic. Or alternatively, what you're going to do is that you are going to, once it's signed into law, you're going to constitutionally challenge it. What's your approach? What are you going to do?
The long and short of it is that this bill is badly written and it will destroy the creative sector. And as Herman indicated, no one can be asked to write whether the best novel or the best academic or the book or the best textbook or produce the best film when that film is going to be used for free and the creators are not paid for it. So this bill is going to damage the creative sectors. And the message that we're getting out really is that without really getting academic about this bill will damage the creative sectors. This bill will ensure that there is a decline in the production of cultural works. And that is the message we're sending to the president. We're requesting the president to realize that the consultation process has been a sham. Both the DTI and Parliament completely dismissed the many, many submissions that were sent, because it is clear now to us that they wanted to achieve a preconceived notion of the bill they wanted. And because we are aware that this country's creative industry will be destroyed in no time, we are appealing to the President. Sure, we can go to the Constitutional Court, we can do all those things, but what the message we'd like to send to the President is that there is a willful agenda to destroy the cultural and creative industries purely for some political gain or some ends that we're not aware of, and we're saying, please help us
cease and desist, basically. Look, just as a final issue then, you have obviously signed a petition, you've delivered it to the President. Have you received any word from the Presidency? Are they entertaining it? As you said, you don't want to go through an expensive litigation process, so I take it that's why you then embarked on this this process with the petition.
Yes. However, if, as I say, because this bill will damage the creative sectors, if we have no option, that option is still open. We shall
of course, which is true, yeah. But I'm just saying, have you heard anything based on the petition that you sent through to the President?
No, we've had anything. We haven't had anything. What we did have was a request by the Minister of Trade of the Department of Trade and Industry, as well as the Minister of Arts and Culture, to come to a meeting. To attend the meeting yesterday, but that meeting did not achieve anything. We actually did not think there was nothing on the table to substantively move us forward, and as a result, on our part, that meeting really amounted to zero. So we're still waiting to hear what the Presidency says.
Okay, let's leave it there. Thank you so much, and all the best to you on these endeavors. Obviously not a very easy one, and I think a much more complex conversation there. Mpuka Radinki, Executive Director of the Publishers Association of South Africa.